Vande Mataram. Dear friends, welcome back to my channel, Courtroom Battles. My name is Dr. TUSHAR MANDLEKAR and I welcome you to the journey of law with me in this channel. Dear friends, I have decided to start a series of certain videos for accident insurance claims. A lot of people have requested that they need some guidance in the matter of the insurance claims which are required to be granted by the motor accident claim tribunals when the claim is raised by the insured or the accident person. Such a claim is required to be decided by the Motor Vehicle Accidents Claim Tribunal under Section 173 of the Motor Vehicles Act. So we will be discussing several judgments and the settled law of the Supreme Court of India in insurance claims. Keep on watching Courtroom Battles. Dear friends, this National Insurance Company vs. SWARN is a landmark judgment and it has changed the entire dimension of the insurance claims in the country. The summary of the findings of the Honorable Supreme Court are as below. 1. Chapter 11 of the Motor Vehicle Act 1988 providing compulsory insurance of the vehicles against third-party risk is a social welfare legislation to extend relief by compensation to victims of the accidents caused by use of the motor vehicles. The provisions of compulsory insurance coverage of all vehicles are with this paramount object, and the provisions of the Act have to be so interpreted as to effectuate the said object. Number 2. An insurer is entitled to raise a defense in a claim petition filed under Section 163A or Section 166 of the Motor Vehicle Act 1988 in terms of Section 149(2)(a) Roman 2 of the said Act. The defences which are available to the insurance companies are enumerated under Section 149(2). Number 3. The breach of policy condition, that is disqualification of the driver or invalid driving license of the driver as contained in subsection 2(a) Roman 2 of the Section 149 has to be proved to have been committed by the insured for avoiding liability by the insurer. Mere absence, fake or invalid driving license or disqualification of a driver for driving at the relevant time are not in themselves defences available to the insurer against either the insured or the third parties. To avoid its liability towards the insurer has to prove that the insured was guilty of negligence and failed to exercise reasonable care in the matter of fulfilling the condition of the policy regarding use of the vehicles by a duly licensed driver or one who was not disqualified to drive at the relevant time. So dear friends, the insurance company has to prove that the owner of the vehicle has deliberately permitted the driver of the vehicle to drive the vehicle which caused the accident in the event if he do not possess a valid license 1, or he possesses a fake license 2, or the license is expired, or he do not have any valid license. 4. Insurance companies, however, with a view to avoid their liability, must not only establish the available defences raised in the said proceedings, but also establish breach on the part of the owner of the vehicle. The burden of proof would be on the insurance company. Dear friends, it is most important fact that the insurance company which claims the breach of the policy has to prove the breach in the tribunal. It is found and observed that the evidence placed before the Honorable Tribunal is not sufficient enough to prove that the owner has deliberately violated the breach or the policy. 5. The court cannot lay down any criteria as to how said burden would be discharged, as much as same would be depending upon the facts and circumstances of each case. The insurance company has the burden to prove that the breach of the policy of the owner is intentional. 6. Even where the insurer is able to prove breach on the part of the insured concerning the policy condition regarding holding of a valid license by the driver or his qualification to drive during the relevant period, the insurer would not be allowed to avoid its liability towards the insured unless the said breach of the breaches on the conditions of the driving license are so fundamental as are found to have been contributed to the cause of the accident. The tribunals, in interpreting the policy conditions, would apply the rule of main purpose and the concept of fundamental breach to allow defences available to the insurer under section 149(2) of the Act. Dear friends, the breach of the policy conditions cannot be mechanically allowed by the tribunal, and even if there is a breach, the fundamental violation of the Motor Vehicle Act does not per se permit the insurance company to deny the claim to the compensation. The grave negligent attitude of the owner needs to be proved. 7. The question as to whether the owner has taken a reasonable care to find out as to whether the driving license produced by the driver is fake or otherwise does not fulfill the requirement of law or not will have to be determined in each case. Dear friends, if the owner has a due diligence at the time of keeping a driver or employing a driver on his vehicle, looking at his license or the genuineness of the license, then owner is not supposed to make the entire inquiry about the fakeness of the license. 8. If a vehicle at the time of accident was driven by a person having a learner's license, the insurance companies would be liable to satisfy the decree. Now there cannot be a defense of the insurance companies that the owner or the driver of the license at the time of driving the vehicle has only a learner's license. Even the learner's license is said to be a license by the Honorable Supreme Court. Number 9. The claims tribunal constituted under section 165, read with section 168, is empowered to adjudicate all claims in respect of the accidents involving death or bodily injury or damage to property of the third party arising in the use of the motor vehicle. The said power of the tribunal is not restricted to decide the claims inter se between claimant or claimants on one side and the insured, insurer and driver on the other. In the course of adjudicating the claim for compensation and to decide the availability of the defense or defenses to the insurer, the tribunal has necessarily the power and jurisdiction to decide disputes inter se between the insurer and the insured. The decision rendered on the claims and disputes inter se between the insurer and the insured in the course of the adjudication of the claim for compensation by the claimants and the award made thereon is enforceable and executable in the same manner as provided in section 174 of the Act for enforcement and execution of the award in the favour of the claimants. 10. Where, on adjudication of the claim under the Act, the tribunal arrives at a conclusion that the insurer has satisfactorily proved its defence in accordance with the provisions of section 149(2), read with subsection 7, as interpreted by this court above, the tribunal can direct the insurer is liable to be reimbursed by the insured for the compensation and other amounts which it has been compelled to pay to the third party under the award of the tribunal. Such determination of the claim by the tribunal will be enforceable and the money found due to the insurer from the insured will be recoverable on a certificate issued by the tribunal to the collector in the same manner under section 174 of the Act. In the event if the insured company has succeeded in proving that breach of the policy is made by the owner as stated in this judgment, then the tribunal will direct the insurance company to make the payment to the affected third party and the same can be recovered from the vehicle owner later on. 11. The provisions contained in subsection 4 with the proviso thereunder and subsection 5 which are intended to cover specified contingencies mentioned therein to enable the insurer to recover the amount paid under the contract of the insurance on behalf of the insured can be taken recourse to by the tribunal and be extended to the claims and defences of the insurer against the insured by relegating them to the remedy before the regular court in cases where on given facts and circumstances adjudication of their claims inter se might delay the adjudication of the claims of the victims. So dear friends, these are landmark guidelines issued by the Honorable Supreme Court of India in the matter of the license for the purpose of giving claims to the third parties. It is often found and observed that the insurance companies come up with the defenses and deny the claim to the third parties. But the Honorable Supreme Court has made it very clear in this judgment that falsifiable or fallible defenses are not available to the insurance companies to repudiate the claim. The Motor Vehicle Act is a social legislation and welfare legislation. The purpose of insurance policy is to give benefit to the person who is injured or dead in the motor vehicle accident. So a broad perspective is required to be taken into consideration at the time of while granting the compensation for the affected persons. I hope you have liked this video. Dear friends, if you are a student of law or a lawyer or interested in law, then please join my channel. If you like this video, please like it. Don't forget to share this video with your friends and families. Please subscribe to my channel. Thank you so much. Jai Hind, Jai Bharat.